recording. Right, now, because we've got quite a few people in the lesson, this allows us to do several things. First, unfortunately, it limits the amount of time which we've each got to speak. So this is going to be in the nature really of a lecture with exercises for you to complete. I'm going to ask you to complete the exercises by writing in the chat box, which you will find by moving your cursor over the bottom of the screen, and you can see a little box saying chat box. Let's just have a quick look at the messages that are coming in first of all. Great. Now, the other thing is this, however, let's let Christina and Deanna in just a moment. Some more people joining us. Excuse me. Christina, Deanna, Marina, good evening. Thank you very much for joining us this evening, and welcome to our lesson. There will be, let's let Olga in as well. Right, okay, so there's 30 of us. Good.
Hello.
Good evening, Katerina. Good evening, Olga. Good evening, everyone. Thank you very much. Deanna, thank you very much for joining us. It's very nice to see all of you online. It's very good of Mark. It's very good of you also to put your trust in me to assist you in improving your legal English. The purpose of this course is to improve your legal English and your legal writing ability sufficient so that you will find it easier to find employment in the UK. In relation to this, we have to have a topic for every lesson. So we're going to look at legal topics. This evening, we're going to continue looking at the topic of working as a lawyer. So we're going to deal with the vocabulary of working as a lawyer in the UK and in the common law courts, common law countries. What we will turn to in our next lesson will be the language of contracts and contract law and contract drafting, which I think will probably be useful to you in your employment in the UK. Right, so we have been, in earlier lessons, looking at a textbook. However, the textbook, the people who wrote the textbook are very protective of their copyright, and I am a little concerned about continuing to use their textbook and to send each of you a copy of it without paying them. They want $50 or $60 US for each textbook that is used. That's too much to ask you to pay, and I can't afford to pay $2,000 to equip the 30 of you with a textbook each. So I'm going to swap to a different textbook. Now, again, the copyright of this textbook is owned by another company. However, for reasons which have nothing to do with me, Kiev Mohila University, for some reason, decided several years ago, 5 or 6 years ago, to put a copy of the textbook for free on the internet. So I'm going to write to everybody after this lesson with a copy of the recording and the link to a free copy of the textbook. And we're going to use that textbook in our lesson this evening. It's filled with exercises, with answers, plus relating to writing and speaking, as well as vocabulary. And it deals with a lot of common law legal topics: company and corporate law, contract law, employment law, banking and finance law, the law relating to debtors and creditors, intellectual property law, European Union, anti-monopoly law. You will find, I'll just let Natasha in, excuse me, one last person let in. You will find, although you're trained as Ukrainian lawyers, you'll find when it comes to company and commercial law, The law is very similar in every country around the world, regardless of whether it's the law in the UAE, following the commercial code of Dubai or Abu Dhabi, or the commercial code of Brazil. My company trains lawyers around the world. I run training around the world. So I can tell you that more or less, when it comes to business law around the world is pretty similar, regardless of whether it's the law of the UAE or the law of Chile or the law of the UK. It's all the same principles, it's just the law has different ways of achieving the same things. Right, so what we're going to do this evening, I'm going to now switch off my video. I'm going to invite all of you to switch off your videos as well, so we can divert all our power to the audio. Then I'm going to share my screen, bring up the textbook I'm referring to, and we're going to look at an exercise relating to the vocabulary of the people you will meet in a common law court. Judges, solicitors, barristers, witnesses, expert witnesses, etc. Right, so let's stop my video. Then let's share my screen. Now let's bring up the textbook. Now let's increase the size of this. Yeah, perhaps you can see this in the screen. Now, simple rule about all my lessons. Please feel free to ask any questions you like about legal writing, contract drafting, contract law, or any legal topic at any time during any of the lessons, because otherwise, all I'm doing is lecturing to a computer screen. Not very exciting for me. So here is, where are we? First, we're going to deal with what we would call an organogram. Let me just get this right. Ah, here we are. Right. Let's move this out of the way. There we are. Let's oh, so it's still people joining us. Excuse me. Sorry, this is just let them in. And the right. Okay. Now here is an organogram. Great. Right. In the middle is the word court. In the outer, the middle ring, are the names or titles of people you're going to meet at court. The judge, you can understand what a judge does. In the outer ring is a little balloon with a definition of what this person does. So judge, we all know what a judge is. A judge is a public official who has the authority to hear and decide cases. Fine. Now, court clerk, okay, down at the bottom. A court clerk is an employee who takes records, records what's said in court, files papers, issues legal processes, documents. Now, as you can see in the outer ring, numbers 1, 2, 5, 6, 4, and 6. These are definitions which need filling in. You can see in the ovals 3 and 4, these are the names of the types of people you'll meet at court. For example, we know what a clerk is, right? Let's look at the word next to the clerk, advocate. We have virtually the same word in Latin or in English or in Ukrainian. So here, A, B, C, D, E, F, these are some of the definitions. So what should we write in circle or oval number 6? This is an advocate. What's the definition of an advocate? Is it, when I write the answer for me in the chat box, here, the chat box, okay? Right, so there's the chat box. You move your cursor. So is the answer A, B, C, D, E, or F? Now, this isn't a race, but I do want you, even if you don't know the answer, to take a guess, because otherwise it's very boring just to listen to me lecture at you through the computer. So who or what is an advocate? Good, that's right, 6 of you, that's good. 7, let's say wait till we get to 10, then I'll look at some answers. This isn't a difficult question. So who or what is an advocate? A, B, C, D, E, or F? 10. Well, of course, it's E. Now, what is E? A person who pleads cases. That's the verb to speak on behalf of a client in court, to plead. It's the language of the priests from 1500 years ago, when the priests in the UK were made the lawyers. Once the Romans left Britain in the middle of the 5th century, there was nobody left in the country who knew how to read or write. Within 70 years, all the schools closed. Good, Irina, good. And so the only people left on the island of Britannia who knew how to read or write were the priests. They made the priests the lawyers. And this is the language of the priests, which is still with us 1500 years later. All right, good. Now, here's a more difficult one for you, okay? Who or what is a bailiff? A bailiff. This is Norman French language. We looked at it in an earlier lesson. Bailey, bailiwick, bailment. It's Norman French from the time of William the Conqueror and his son, Rufus, King Rufus, and the Plantagenets, Richard the Thirst. Right, so who or what is a bailiff? A, B, C, D, or F? It's D, quite right. A bailiff is an officer of the court whose duties include keeping order in the court and assisting the judge and the jurors, and also assisting the court with enforcing the court orders. That is a bailiff. Right, now, very important in the common law, in relation to both criminal and civil matters, is this person for circle number 2, a reasonably prudent person. The common law is based on people's behavior, their normal behavior. If the court feels that somebody's behavior is acceptable or reasonable, then everything is fine. There's no problem, no crime. If, on the other hand, their behavior is unreasonable, then they've probably committed a crime, or they've been careless of, or they're guilty of being careless or negligent and can be sued for the damage they've caused to somebody else. So who or what is a reasonably prudent person? Correct. Correct, Julia, Maxine, Indiana, Katerina. Oh, everybody's got it. Very good. F, good, Vika. F. It's a hypothetical person. In other words, doesn't actually physically exist. A hypothetical person who uses good judgment or common sense and/or common sense in handling practical matters. Such a person's actions are the guide in deciding or determining whether their individual's actions, the actions of that person, were reasonable, whether they have behaved in accordance with the law or broken the law. Good. Right, so here's a fairly simple one. Who or what is number 1, the defendant or respondent? Who is that? Quite right. But who or what is the defendant or respondent? Okay, let me see. I'm going to just check. Okay. Irina, I'm just going to mute your... those of you who aren't muted, can I ask you just to mute your phones for me? Mute your computers or phones. So who or what is a defendant or a respondent? It's C, the person who's sued in a civil lawsuit. All right, this is a bit too easy for all of you. That's good. Well, just do number 3 then. Who or what is this? A person who has specialized knowledge of a particular subject who is called to give evidence, which we say is to testify, to give evidence on oath, or to give evidence in a court, just having promised or sworn on the Bible or some holy book to tell the truth. We call this evidence. And what they're giving is testimony. That's another word for evidence. Testimony, synonym. So a person who has specialized knowledge is called to testify is an expert witness. Good. Well, that's very easy, okay? So we've all got you. I've got you thinking now in English. Good, Olga. Good, Maxine. I've got you thinking in English. So let's move on to something a bit more complex. All right? What we have here are the documents that would be used in a court case. I'm going to explain what these words mean, and I'm going to send you this exercise as a home task. First, affidavit. Well, as you can imagine, that's a Latin word. Okay. An affidavit is used as evidence, partus libellarium, is used as evidence in a case. It's a written statement by a witness who swears on the Bible in front of a lawyer to tell the truth in their written statement, knowing the written statement is going to be used as evidence in a court case. If you lie in your affidavit, you are guilty of the crime, the criminal offense of perjury. Just going to write this in the chat box. Perjury is the crime of giving false evidence, lying in court, in other words. It's a criminal offense. The judge, the maximum sentence is, can I, whoever, I know that you're having to babysit, I know you have your families with you. Can I ask whoever has the young child with them just to mute their microphone? That would be great. Okay. So perjury, perjury is a crime of giving false evidence. The maximum sentence, because it's a criminal offense, is 7 years imprisonment and or unlimited fine. Now, the worst case, the most recent bad case of perjury involved a lord, not a law lord, but a lord, the very famous author who's now in the House of Lords. I've forgotten his name now, but he lied in a civil trial. And he was sentenced to 5 years imprisonment. Now, he's a multimillionaire. He had to pay a fine as well, but it was the 5 years imprisonment. So the courts take it very seriously. Right. So an answer. When somebody is sued in a civil matter, a claim is made against them. They must show that they intend to defend the case by filing or sending to the court an answer. This states why they should not have a judgment entered against them. Okay, all right. Okay. Now, let me just see if I can. There we are. There we are. It's better. Okay. Now, a brief. Brief is a word with several meanings. To be brief means be short, right? Be quick. A brief case, known in French as a portfolio, right, to carry files, a briefcase. It's a case to carry your papers. Your papers show the main points of the case in just a few short documents. That's why these documents are called briefs. When you instruct a lawyer, a barrister, for example, with the wig, the papers you send are called the brief. In idiomatic language, amongst the criminals in London and many other major cities in the UK, the lawyer who will represent the criminals in court is known as their brief. So it means to be short, and in the law, it means the case set out in a few short papers. Right, a complaint. Well, this is the actual summons complaining about the civil matter. An injunction. An injunction is one of the orders which a civil law judge in any civil law country, and say a common law judge in any common law country, can impose upon the parties, either before the case starts, during the case, or even as a judgment. An injunction is an order of the court to stop doing something. Now, this power does not come from statute. This power comes from the common law. And because of this, the judges can use an injunction to order somebody to stop doing something. Usually they do it before the case is finished, to stop somebody damaging the property so that it will still have a value when the case is finished. This is one of the orders which a judge can make under the law of equity. Equity is an area of the law in all common law countries which relates to fairness. It refers to the power of a common law judge to ignore what a statute says, to ignore what the law says, in order to give a judgment that is fair to the parties. There are two equitable orders which judges can give in civil law cases. One is an injunction, an order to stop doing something. And the other is an order to do something, which we call an order for specific performance. Let me just write that in the chat box for you, okay? I'm going to send you this exercise as a home task. So it's great that you're filling in the answers now, but I'm going to send it as a home task. Okay, specific performance, in order to do something. For example, sign this document, which will transfer the ownership of your land. Hand over the painting, the portrait, which you have painted because the claimant paid you $10,000 to paint his or her painting, likeness. So it's an order to do something, an order for specific performance. Tell us where you have hidden the car that belongs to your ex-partner. Yeah? Right, a motion. A motion is an application to the court, either before or during a trial. A motion can be made at any time, right up until the announcement of the final judgment. It's an application to the court. It could be an application to adjourn the proceedings, or to limit the number of witnesses, or to increase the number of witnesses, or to include extra evidence, or to keep evidence out. Any sort of application to the court, either before the trial or during the trial, right up until the final decision is announced in the trial. And a pleading, remember that word from the priests? A pleading is a written document setting out the main points of the case. It could be from the complainant, or it could be from the respondent or defendant. And a writ. A writ, this comes from 700 or 800 years ago, when you had to put your claim in writing. Now, 700 or 800 years ago in the UK, most people did not know how to read or write. So there were people hanging around the court, the bailiffs and others, who would help them write their claim. And when they'd written it down on a piece of paper, parchment, and handed it into the court, it was written. So they called it a writ. It's the claim in a major civil case, not a summons, but a writ, for a large amount of money or a large item. And we call it a writ because it's written and handed to the court. These people who are hanging around the court, the bailiffs and others who are helping the court and helping people write their claims, gradually came to be recognized by the court. And about 400 years ago, they were given a special title, solicitors. That is how the solicitor's profession came into being. They were people who helped out at court by making claims and giving advice at court to people who were appearing before the court. Right. Now then, what we're going to do here, we're going to complete exercise 15. Let's increase the size of this again. I'm going to send you that little exercise as a home task. Let's deal with exercise 15. What we've got here are 5 verbs. These verbs collocate, that is, they are used together with the word document. The verb is to draft a document, or number 2, to issue a document, or number 3, to file a document, 4, serve a document, 5, submit a document. Now, you have to tell me what each of these verbs means. We got 5 definitions from A to E, but they've been mixed up. So let's have a look at definition A. And this means to deliver a legal document to someone demanding that they go to a court of law or that they obey an order, like an injunction or orders for specific performance. What is that? Is that 1, 2, 3, 4, 5, 1, 2, 3, 4, or 5? To deliver a legal document to someone. What will that be? Just write it in the chat box again for me, okay? Now, remember, it's not a race. What I want you to do is take your time and make sure you get it right. I'll wait until I've got about 10 answers, then I'll see what you've written, okay? Eight. Anybody else want to? Now, at this stage in the course, there are no wrong answers. Don't forget, if you could do this without my help, I would serve absolutely no purpose in providing this course. So, what's the answer to A? Good, 10. Let's have a look. It's, what have we got? 4, 4, 5, 3. Okay. Well, to deliver is number 4. It is to serve a document on somebody. Now, up to about 30 years ago, to serve a document, you used to have to actually touch them with it, physically, with a physical piece of paper. However, with the computer age, with emails, faxes, Twitter even, courts now allow you to serve documents without actually touching people with it. You merely have to show to the court that it's highly likely that they will know about the legal proceedings. So there have been cases where divorce applications have been served merely by the service of by showing that a message had been sent on Twitter and that the person to whom the document needed to be served always followed Twitter. So you don't have to physically touch them with it anymore. That's serving a document. If you have an injunction, You can't expect somebody to stop doing something until they know about the injunction. So you must serve it on them, possibly by email these days, or by telephoning them even. Right. Okay, what's B? What does B refer to? To produce a piece of writing or a plan that you intend to change later. What verb is that? To what a document? This is an easy one. I think you're all going to get this. It's the initial version, the first version of the document. Could be a contract, could be a statement, could be an affidavit. Yes, to draft a document. Good, Vika, good, Yulia. Who else? Diana, Sergey, good, good, good. To draft a document. Right. Now, what does this mean? Which verb is this? C. To deliver a document formally, which means officially, for a decision made by others. To deliver a document formally for a decision to be made by others. What's that? Well, you've all put to file, which is almost correct. But don't forget, you could file an affidavit. You could file a witness order. You could file an application. In fact, to deliver a document formally for a decision made by others is to put it under the eyes of the judge. So in fact, it's 5. It is to submit a document to an authority. To submit. A decision is going to be made by others. So we rely on the others. We will submit to their decision. So, Olga, good. It's 5. It is to submit a document to an authority. Okay, that is C. Now, D, a little easier. What is to can't see the answer to this myself. All right. To officially record something. To officially record something. It could be to put something into the court record. It could be for the court itself to write it down and keep that record. To officially record something. What would that be? These are bad definitions. I know the people who wrote this book. They're academics at Cambridge University and some well-known legal English teachers working outside the UK. But all of them are academics. They're not official. They're not working lawyers. That's why some of these definitions are very strange. Okay. 3. Very good. 3. To file a document with an authority. Means to officially record it by putting it into the court file or by writing it down and keeping it on the court file. It is to file a document, to officially record it. And lastly, to produce something official, say a document. To produce something official, like a court order. Yes, it's to issue a document. Good, Valeria. Good, Irina. Good, Ludmila. Good. All right. Well, that's enough for vocabulary. Otherwise, we'll never get anywhere. Now, one of the difficulties, I'm going to change topics. We're going to deal with vocabulary, but we're going to deal with vocabulary, which you're going to have, I think, some difficulty with. Because, as you probably know, the English language, like French, Italian, Spanish, Portuguese, is in fact based on Latin. Around 70% of the words in English have a Latin base. In fact, there are some words in English which have been taken straight from Latin. Vice versa, contra, per annum, e.g. stands for exemplar gratia, for example. Now, there are some words which are just straight Latin words. Let's have a look at this text in grey writing on the screen now. Right, you can see in the top line, the claim for breach of contract fails inter alia. Right, inter means between. Alia means other things, which gave us the word aliens. They're different from us, they're other things. So the claim for breach of contract fails between other things or amongst other things to state facts sufficient to constitute, in other words, to create or make up, constitute a cause of action. Yeah. Let's go to the second paragraph. The complaint alleges is to state without proof, to allege. Breach of contract as follows. And now here we're quoting exactly what the complaint states. So we put it in inverted commas to show we're quoting. At all times herein mentioned, plaintiffs were part SIC, S-I-C. It's in brackets. Plaintiffs were a part to the construction contract. Well, we use these words, we use this word SIC in brackets to show that we're quoting from somebody who's made a spelling or a grammar mistake. And here they've made a spelling mistake. They weren't they were a party. Party to the construction contract. So when we quote somebody who has made a spelling mistake or a grammar mistake or used the wrong word, and we have to quote exactly what they've said, we write the word like this, SIC, in brackets, to show that we have spotted their mistake. It's not our mistake. We haven't said they were a part. We would say they were a party. But we're showing that there's a mistake there and we've spotted it. And we write the word SIC to show that we've spotted it. It's a mistake. We write it immediately after the mistake. It means, Latin word meaning thus, T-H-U-S, thus. Okay, right. Let's have a look at the last paragraph. On its face, the claim alleges only that defendants breached the construction contract. But Longco is not a party to the construction contract. Therefore, Longco cannot be liable for its breach. See, e.g., the first letters of the Latin words exemplar gratia, meaning example given, meaning for example. For example, the case of GSI Enterprises Incorporated, V. V stands for verses. However, in the common law countries, it has been our tradition for several hundred years to never use the word verses, to never use the word verses or V. We write V to show its verses, and we read the name of the case as this, GSI Enterprises and Warner, first reported in 1993. So although it says V, we read it as we see it, and we say and. Whenever you see these two initials, E, G, we know what they stand for, but we say, when we're reading it out loud, we say C, for example. We don't say exemplar gratia or e.g., we say, for example, C, for example, GSI Enterprises Incorporated and Warner, 1993. Inc. is the American way of saying limited. We put Inc. to show it's an incorporated body. It's a company. It's an American company. It's incorporated. In England, we put LTD to show it's limited. It's a company. with limited liability. Right, now, okay, so just to show you how Latin has crept into our ordinary English writing. Now here, Latin is very old-fashioned. And it would be great if you could write all your texts without using it. But you will find other lawyers use it, and you'll have to understand it, even though I don't want you to use it yourselves. So here's a little exercise, okay? What does, for example, what does ad hoc mean? An ad hoc committee. Let me just see if I can just what does an ad hoc committee mean? What is ad hoc mean? Is it A, B, C, D, E, F, G, or H? Well, let me tell you, okay? Ad hoc means for one purpose only. So, for example, there's been a train crash. A committee is set up to examine the reasons for the train crash. So it's an ad hoc committee. It only has one purpose. Ad hoc means for one purpose only. So ad hoc means for this purpose. Yeah. Now, sick, you know what sick means. I've just explained it to you.
It's sick not ad hoc. It's not all inclusive, not ad hoc.
Like no, not at all. It means for one purpose only. For example, there is a committee in the company which decides on the wages of each member of the staff, the salary. It's the ad hoc remuneration or salary committee. It only has one purpose, to examine the salaries of the staff. Okay. Now, sick, as I've shown you, means, where are we? Thus, which we use after a word to show that it's incorrect. Now, etc., more Latin, etc. We write it as this, etc. We use it in Latin a lot. We use it in contracts a lot as well, unfortunately. You shouldn't. You should actually write out the full list. But unfortunately, people write etc. Etc. means, and other things, it's F, and other things of the same kind. Yeah. So I will sell you my farm with all the cows, horses, sheep, goats, pigs, ducks, etc., meaning all the animals that live outside the house. Now that's things. When we come to human beings, we write this, et ali, which we shorten to et al, meaning other people of the same kind. So I dislike all politicians. I mean, I'll tell you the truth. I dislike all politicians. I dislike Tony Blair. I dislike I just dislike all of them. I dislike Suella Braverman. I dislike Keir Starmer particularly. I dislike Gordon Brown, et al, and other people of the same kind. So et al is usually used in legal writing when you've got, say, 20 defendants. You just name 2 or 3 of them, and then you say et al. It shortens the list of people that you're going to name. Others, people of the same kind. Et al. Okay. So you've done ad hoc, et al, etc. Exemplar gratia, we look id est. Now you'll use this a lot. We shorten it to the 30 initial letters of the first of the words, i.e., meaning that is. Id means that. Est means is in Latin. Id est. So there's only one thing wrong with this contract, i.e., it's written in German. In other words, the one thing. There's only one thing wrong with this contract, that is, it's written in German. You'll find that i.e. is used a lot by lawyers in the UK. I've got one objection, i.e., I dislike the amount of money to be paid. i.e. stands for id est, which means at H, that is, okay? Now, per se, more Latin. Again, used a lot. Per se means by itself, self. Per se, by itself. Se gave us the word self. Per gave us the word by. Per annum, meaning each year. Per means each, and se means self. So per se means by itself. So, for example, usually an adult is capable of conducting legal proceedings by themselves without having a lawyer. They are legally competent per se, by itself, per se. Okay. And versus, or sic we looked at, and versus, written either VS or V, means against. Okay, right. Now, here are some more that you may know. This time I'm going to ask you to answer these for me. Let's deal with one that you'll know. Okay, number 4. The rent is $10,000 per annum. What does that mean? Per means each. So what does per annum mean? The rent is $10,000 per annum. What does that mean?
Per year.
Absolutely.
Per year.
Absolutely, Sergey. But I'm going to ask you to write in the chat box, otherwise everybody hears and doesn't have to answer themselves. Good. B, good. Per year. Right. Now, here's a word the same in Ukrainian as Latin as English. Quorum. There are 6 directors needed to make a quorum for company meetings. What does quorum mean? A, B, C, D, E, F, G, or H? C, quite right. The minimum number of shareholders or directors who have to be present at board meetings or company meetings so that decisions will be valid. Right. Now let's go to number 1, de facto. We use this a lot. The purchase of 65% of the shares was a de facto takeover. What do we mean, de facto? Facto, of course, gave us the word fact. Of course, it's D, in fact, D. A de facto takeover means, in fact, it's a takeover. Now, ipso facto, another word with fact. Ipso facto, what does that mean? What does ipso facto mean? It's got something to do with facts. Okay, very good, those of you. Ipso facto means by that very fact itself. For example, you have not paid us the money you should pay us under the contract. Ipso facto, you have broken the contract. Ipso facto means by that very fact itself, by that single fact, ipso facto, by that single fact, something has occurred. G, very good, Valeria. All right. Now, inter alia, I've already told you, means between, well, what does inter alia mean? A, B, C, D, E, F, G, H, I, or J. Let's see if you're paying attention. Good. A, ipso facto. I'm saying not ipso facto. Inter alia, inter, between or amongst, alia, other things, among other things. A, good, Vika, right. Inter alia, per annum, you know, means each year. Pro forma. What does pro forma mean? I do work at your house and you pay me in cash. And 6 months later, I come to you and say, I need to give you an invoice and for you to sign it to show the tax authorities. All the work has been done, all the money's been paid. It's H. It's as a matter of form or protocol. A pro forma document is a document which is purely produced for the protocol, for the official method of doing something. Quorum we know. Sui juris. Sui juris. Adults, adult human beings who are not mental patients and not bankrupts and not subject to serving in prisons or citizens of a state with which your country is at war. All of those, by the way, you cannot make a contract with. Every other human being is sui juris. So what does sui juris mean? Okay. Sui juris means E, of your own right, able to exercise your own legal rights. Every adult, you're all, I anticipate, adults, so you're all sui juris. You're able to exercise your own legal rights without having to ask permission or having to require a lawyer to act for you. You're all capable of starting proceedings or defending proceedings yourselves. You're sui juris. Okay, ultra vires. Now, you may bring proceedings against an organization which you say, or a court, or a council, or a company, which you say has acted ultra vires. It's an order you can apply for the court. I want an order from the court that the council, the local council, has exceeded its powers. It's acted ultra, beyond. Vires, their powers. J. Very good, Diana. Very good, Anastasia. Very good, Irina. Ultra vires means you've acted beyond your powers. Now, when you start a company, in the common law countries, this is the next topic we're going to look at in the next lesson. We're actually going to move to legal topics from our next lesson. The two documents forming the constitution of the company are the Memorandum of Association and the Articles of Association in the UK. The memorandum sets out the powers of the company, its objectives, the number of shares it allows itself to sell, the price at which it can sell those shares. It gives itself these powers. The internal rules of the company, how many directors are needed for a meeting, how much notice there must be of shareholders' meetings, things like this. These are all contained in the Articles of Association. So the Memorandum of Association sets out the powers. Now, if the company hasn't given itself the powers to do certain things, it can't do them. It will be acting ultra vires. It'll be beyond the legal powers of a body. Okay? And vide licit. Vide licit means already seen, or rather as follows. Vide licit. And again, we write it vis. We don't write vide licit, we write vis. We shorten it. Means as follows. Okay? All right. Now, I'm going to just deal with this, and then we're going to finish for this evening. We talked about collocations. Let me explain. This is an English teacher's word. A collocation refers to two or more words that are used together so frequently that the meaning of the two or three words used together has a different meaning from the meaning of the individual words, like motor racing, fast food. We know what fast means, quick, speedy. And we know what food means, stuff you eat. And fast food, well, it doesn't mean food that runs around and races around. It means it's food that is prepared quickly. Motor racing. Okay, you know what a motor is? Drives a vehicle. And you know what racing is? Motor racing, however, has a special meaning. It's a collocation. Right. Now, in the law, in legal English, there are lots of collocations that consist of a verb with a noun. Now, here, numbers 1 to 6 are a number of verbs. Advise, to draft, to litigate, to practice, to represent, to research. And in the box are a number of nouns. Cases, clients, contracts, corporations, decisions, defenders. Right, now then, as collocations, let me give you the first one for advise. We can advise clients, right? Okay. Now, what else can we advise? This time I'm going to invite you to speak. So you can all shout out at once if you like. What else can we advise, or who else can we advise? We advise clients. What else do we advise? There's at least two more there that we advise in the box. What other nouns go collocate with the word advise? To advise what? Anyone? Oh, okay, you're writing the box. Okay, advise, good, Olga. We advise corporations, and Sergey, good. We advise defendants. We advise clients, we advise corporations, we advise defendants. Right, you got the idea. Okay, now to draft. What do we draft? What can you draft? You can't draft cases. What can you draft? You can't draft clients. What can you draft? Let's see what we got. Yes, we all draft contracts. Now, there's some more though. What else can you draft apart from contracts? There's two other things we can draft apart from contracts. Can you see what they are? Legislation, very good, Katerina. And, well, we could draft a law, good, Vika, okay? But there's, what else can we draft? There's one other there we can draft. We can draft contracts, we can draft legislation. You could draft a law, okay, a draft law, meaning it's not passed yet, it's a bill. When it's written down, but not yet approved by the Parliament, it's a bill, like you get in a restaurant, a bill, it's a bill. We can also draft decisions. Very good, Katerina, very good, Vika. We can draft decisions, means we write them first of all. We're not sure if we got it exact, so it's a draft decision. Good, Valeria. Right, now litigate. Litigate means deal with court cases, okay? So, some of you will be contract lawyers, some of you will be banking lawyers, some of you will be litigation lawyers, right, going into court. So what can we litigate? Okay, good. Everybody says litigate cases. Of course you can. What else can you litigate? One more. What's the other word that we can litigate in the box? Can anybody see it? Oh, some of you can, good. What else can we litigate? Disputes. We litigate disputes. That is, a dispute is an argument. Dispute is synonym for an argument. We litigate disputes. In other words, we go to court over arguments. Good, we cover there. Okay. Now, practice. What can we practice? What do we practice? Strange verb, really. In conversational English, means to practice means to try until you get it right, to try and try and try to make sure you can do it correctly. Of course, we practice law. I don't know why they say that. We practice medicine as well. You'd think people would want to get it right before they started. But okay, represent. Now, who do we represent? Who do we represent? There's one, two, three nouns in the box that we represent. I'm pretty sure you're all going to give me the first one. Let's have a look at this. Yes, we represent clients and we represent corporations. Corporations meaning companies. We represent clients, we represent corporations. Now there's one other noun in the box. Clients and corporations, certainly, good. But there's one other noun in the box that we also represent. Who or what is that? Okay, not so much legislation, Valeria. Defendants, good, Olga, good, Juliana. Defendants, we represent defendants. About 1,000 years ago, when people were taken in front of the magistrate, the judge. They'd sit in the room and a metal bar would be pulled across the front of the court. If you go to the old court down in the town of Sandwich on the south coast of England, that's one of the 5 Cinque ports. The French spelling, C-I-N-Q, Cinque ports. The very old towns. They were where the wool was exported from England to Europe around 800 years ago. Sandwich is one of the 5 Cinque ports, a very old town. If you go into the court, magistrate's court there, they've still got a metal bar, which they pull across, and then they tell the defendant to go and stand at the bar, because the judge is going to come in and deal with them. And so their advocate would go and stand beside them. The advocate would be called to the bar. The bar actually means a metal bar. So when barristers say they're called to the bar, they're qualified, in other words, they're referring to this idea that they're called to stand beside their client in a court so they can speak on the client's behalf, so they can plead on behalf of their client. They're going to represent their client, the defendant, usually, in a court case. Right, now, research, last one. What can you research? I can see 3 things at least that we can research. What can we research? We research cases, we research law. What else can we research? There's one other there which we haven't used yet in any of the other verbs. There's something else we can use. Don't forget, in the common law, part of our law is what you might call the judicial interpretation of legislation. The judges say what particular words mean, what the legislation means. These are called precedents. If a senior judge in a senior court says this is what the law means, then all the other judges below that level must follow that ruling. This is what we call precedent or judge-made law. So we research good, Irina, good, Miller. We research decisions. It's part of our precedent, law of precedent. Good. All right, well now what we're going to do, that's dealt with the very basic things in the first 3 lessons, okay? And I'm a bit tired of this. So what we're going to do, let me just show you. What we're going to do next is we're going to jump ahead. Get rid of all, and I've had enough of this. We're going to move, I think we'll go to lesson 5. We're going to come back to company and corporate law. And in the next lesson, we're going to start looking at contract law, common law, contract law. Where are we? Excuse me just a moment, let me come to it. Oh dear. Contract, let me do. Right. Contract remedies and contract law is, here we are. Contract formation, good. We're going to start looking at the law of contracts and the words relating to contracts. I'm going to be sending you the text. I'm going to send you the link to this book so you've all got it, so you can all refer to it, and I can ask you to complete exercises from the book. Now, very usefully for me, the answers to the exercises are at the back of the book, so you can check your own work later. Now, there's about 30 of you in this lesson. I think, I know the reason why you're taking these lessons is because you want to develop your legal English ability in order to assist you in finding employment. So it would be really useful if you had speaking practice as well. Unfortunately, as there are 30 of you, there's too many of you for you to speak in the lessons. Otherwise, you'll each get 1 minute to practice each. So what I'm going to do is this. I want to split you into, I've got about 60 people who've registered for these lessons. I want to split you up into groups of 6 or 7. And then I want you to get together for 30 minutes to an hour each week. Sometimes I'll join, sometimes I won't. Sometimes other lawyers, English lawyers, will join who have volunteered to do this. And I want you to have speaking practice about a legal topic. I'll give you the topic. It'll probably be one of these texts which I'm going to send you. Now, what I want you to do, I want some of you to volunteer to assist me. There's 60 of you. I want about 10 of you. I want as many people as possible for me to select 10 from, to volunteer to assist me with the distribution of the links to the recordings of the lessons, because I can't send out 60 individual emails. It just takes me too long. And I want you to assist me by being the leader of the group of 6 that'll be in your discussion group. If there's just 6 of you in each discussion group, everybody will have time to practice speaking English. You must practice your English for at least 15 to 20 minutes every day, whether it's by watching a television program, reading a newspaper or a magazine, or speaking with people. Now, I know you're with English families, so I'm sure you're speaking English each day, but you must keep up your practice. Now, I doubt that your English families are lawyers, so it will assist considerably if I give you topics to discuss in your 30 to 60 minute conversation practice, which will take place each week. I want to split you up into 10 groups of 6 people each, so you've all got plenty of time to speak in your groups. And I want as many of you as possible to volunteer to be the administrator of each group. I'll select 10 of you, okay? As long as I get at least 10. But I think it'd be terribly useful to improve your English language ability and your legal English language ability to have this conversation practice. So I'll be writing to everybody probably tomorrow morning with a link to the recording, a copy of the textbook, and then I'm going to remind you to volunteer to be the administrator of one of the conversation groups. We'll undoubtedly have more people joining us next week, so there'll be more conversation groups. All right, has anybody got any questions on anything we've looked at this evening? Anybody want to ask me anything? Anybody want me to make sure I include it in next week's lesson? No? Okay, all right. Well, look, don't be too scared to speak. You know, nobody, the person who never made a mistake, never made anything. And trust me, the first time I ever stood up to speak in court, it was complete shambles. I might seem very confident now. The first time I stood up to speak in court, I was shaking so badly that the piece of paper I had written in my hand with the 6 questions I had to ask written down it was rattling so badly, the judge stopped the case to see what the noise was. That's how nervous I was of speaking. Gone a bit too far the other way now. But don't be afraid to speak English. Nobody, you know, you should hear me try and speak Ukrainian. It's terrible. Okay. All right. Thank you very much, everyone. Now, we'll have another lesson on Wednesday of next week. I'll write to you tomorrow, and I'm going to try and organize these conversation groups. If anybody doesn't want to join a conversation group, let me know. But I think it'd be terribly useful if you did. Let me just see what's written in the chat box. Okay, thank you very much, Christina. Okay, thank you. Thank you, Anastasia. Thank you very much. Thank you, Katerina. Okay, well, I'm glad you're enjoying it. You know, I normally live in Kiev. I've been living in Ukraine for 18 years, so I'm a refugee as well at the moment. That's great, Vitaly. Okay. This week, I'm in Albania. Well, for the next month, I'll be in Albania. I want to go home to Kiev, like you guys do, you know, back to your own. Well. All right, thanks very much, everyone. I hope you enjoyed it. Pleasure to meet everybody, and I'll see you on Wednesday of next week. Okay. Bye-bye for now. Bye-bye. Bye-bye. Bye-bye.
Bye.
Bye-bye. Thank you, Jen. Thank you. Thank you, Rina.
Thank you so much.
Thank you so much.
Thank you, Vika.
Have a nice day.
Okay. Bye, everyone.
Bye.
Stop sharing. I'll send the link to the book as well, by the way, for you to download into your own computers. Okay, bye, everyone.